Good afternoon. I thank council for your flexibility. The next case is John Doe 1K versus Roman Catholic Diocese, and John Doe versus Roman Catholic Diocese. And we will hear from the appellant.
May it please the court, Your Honor, my name's Sam McGee. I represent the plaintiffs in these two cases, both of whom are proceeding as John Doe plaintiffs. I will attempt to reserve 5 minutes for rebuttal. Your Honors, both of these gentlemen were abused repeatedly by two different priests in the Charlotte Catholic Diocese. This happened when my clients were teenagers. They did bring claims before. I will be spending most of my time talking to you not about the issues you've heard before this morning, although those issues are part of this case, but primarily about the res judicata issue, because that's an issue that I have in these cases that you didn't have in the cases that you heard earlier today. These gentlemen brought cases previously, and they were time barred. They were found to have brought their cases after the statute of limitations lapsed when they were 21 years old. Since then, as you know, the General Assembly studied the issue, looked at its own legislative rule, and determined it needed a new legislative rule. Looked at the brain science that says that a lot of victims never come forward, and that many, because of the damage that is done to them by sexual abuse, don't come forward until an average age of 52. So they extended the statute of limitations, but they also had this 2-year window, as Representative Riddell said, a one-shot deal for people who had older claims. My clients were chastised in their first attempt to vindicate their rights for showing up too late. Now the defense, the same defendant, asked for you to dismiss their case a second time for showing up too early, and perhaps to be the only people in the history of American jurisprudence to lose on the statute of limitations because they filed their case too early, before the Safe Child Act was passed.
So in fairness, I would characterize their argument slightly differently, which is you chose the wrong approach to try to bring your claim again and join people like the plaintiffs in the McKinney case we heard this morning. And so if, we talked a lot this morning about how we may be essentially now aligned with federal law. And as I understand the federal law, you have a line of cases, it's like Robertson versus Audubon Society. So, there's a fight over the spotted owl and the logging, and the Audubon Society is winning. So Congress comes in, they pass the Northwest Timber Compromise, they say, they actually reference in the bill that lawsuit, and they say as long as the loggers and the government do these things, they'll win this lawsuit. And the Supreme Court of the United States said that's okay. That's essentially changing the rules of the game before the court has completed the process and entered the judgment. There's no problem there. But then you have Plout versus Spendthrift Farms, which is, there's a question about what the statute of limitations, it's this case really, it's the same sort of fact. So the fight is, what is the statute of limitations? It goes all the way to the Supreme Court. The Supreme Court says statute of limitations is this, affirms these judgments that had dismissed these time-barred claims, and Congress didn't like it. So they came in and said, no, we're gonna pass a law that says all these claims are revitalized, you can bring them again with this new statute of limitations. And the Supreme Court said you can't do that. That intrudes on the judicial branch's authority to enter judgment. And so I guess my question is, if we are determining that it is constitutional it does not violate the vested rights doctrine to have a sort of a revival of this limitations period, shouldn't we also apply similar law of the land due process principle that says it would be a separation of powers violation, though, to set aside the judgment? The legislative branch can't do that. And instead, what you should have done is found another way to go back and get the old judgment set aside and pursue the claim again, because the SAFE Act now has given you an argument to overcome the limitations period.
Okay.
So why is that the wrong approach?
The reason that's the wrong approach, particularly with regard to the separation of powers here, is that we are talking about separations of powers in two different constitutions. And as this court knows, the federal Constitution is a limited grant of power. The concept of limited government was very important to the framers. That is not the way the North Carolina Constitution works. The way the North Carolina Constitution works is that the legislature, standing in the shoes of the people, is restricted only when our Constitution explicitly says that they're restricted. So although I understand the parallel with regard to federal due process and North Carolina law of the land clause, I think when it comes to the separation of powers, it becomes very important that we're talking about two different constitutions.
So I thought about that, but then you look at the Gardner case that we decided in the 1980s. So that's you have this case where you've got a Wayne County spouse and a Johnston County spouse, and the family law case is brought in Wayne County, and the Johnston County spouse says, I'm going to fight it. I think venue should be with me in Johnston County. It goes all the way up to the Court of Appeals. Court of Appeals enters a judgment, no, venue proper here. Then the legislature changes the law and says, actually, because that spouse had moved out of state, you have a right to have the venue moved to your home county, the now in-state spouse. And this court, it's very interesting what this court said, because to the argument we had this morning, there's all this argument about is it a vested right, is this a substantive right? And the court actually says, we're less concerned with the metaphysics of what that is. And then they say that the important point is that they're more concerned with the constitutional requirement that the judgment is stable. And then they cite separation of powers principles. And then it follows then that a legislative declaration may not be given effect to alter or amend a final exercise of the court's rightful jurisdiction. And then they go on to say, so therefore, because the court entered the judgment on the venue question, that can't be changed. So it seems like that's where you are. Now, again, there are ways to set aside a judgment. So that this may not be the end for you, but don't we have to follow this Gardner principle and say, what you're asking us to do here, just file a whole new lawsuit when the same claim has been dismissed, we just can't help you.
I have a couple of things to say about Gardner, but to answer the question directly, no, I don't think we have to follow that Gardner principle. And the reason is Gardner simply doesn't do what Harper versus Hall requires. What Harper versus Hall requires, and we're only looking back now, not to the 80s, but a year and a half ago, says that overturning an act of the legislature is the most serious of judicial considerations, that a restriction on the legislature is in fact a restriction on the people. And that's where this rule comes from, that there has to be an express prohibition on legislative power, and that has to have been violated beyond a reasonable doubt. Gardner does not in any manner look to any specific portion of the Constitution and say this provision right here is violated beyond a reasonable doubt. Now, speaking to Gardner specifically, this was also Mr. Gardner's, I believe, fourth attempt to change venue in the case. And I think it would not be unfair for me to say that sometimes facts influence the law when they're saying enough is enough. You've already done this 3 times and the legislature's changed the law. We're not going to let you take advantage of that. That case is particularly troubling in the fact that venue is generally considered procedural, and our law was otherwise consistent that retroactive changes to procedure are okay. I think that Gardner has some issues standing on its own. I also think it contradicts the Wharton case, which is an older case from this court, where a bond issue was retroactively legalized after this court had said it was illegal. And when it came back to this court, it said that was okay, there wasn't a separation of powers violation.
But what if the way to harmonize, I agree with you, you could make those points, but what if the way that you harmonize is, say, the principle of Gardner that is the holding that we still follow, is the one that is perfectly aligned with what the Supreme Court of the United States has said in Plow, which makes a lot of sense, and that is that the legislature, any legislature, Congress or our General Assembly, is free to change the rules of the game in litigation up until the judgment's entered. But when we invoke our judicial power to enter the judgment, even if the legislature doesn't like the judgment we've entered, they can't change that judgment. Now, there may be other ways for the litigants to go in and ask for the judgment to be set aside, but the General Assembly can't, because if they could do it here, imagine the other things they could do if the plaintiff's bar was getting a series of very large verdicts in, let's say, medical malpractice cases. They could just pass a law that says, no, these judgments are capped at $2 million, something like that. Well, we would say perhaps you could do that prospectively, but we would say, no, once we enter the judgment, you can't change our judgment as a matter of separation of powers doctrine. And so you can see the slippery slope here if we don't adhere to the principle in Gardner.
I understand the slippery slope, but I also feel that when we start saying, but if they can do this, they can do this, we begin to venture into Jones Street territory. I think we begin to venture into policy discussion territory. What our law in the state from this court is that there has to be an express prohibition on legislative power. I invited, and to be fair, when we were in the Court of Appeals, Harper hadn't been decided yet. And so we were arguing about Gardner and Hoke and other cases. But I basically, we engaged in a textual analysis of the Constitution. We looked at where are the restrictions in the Constitution on legislative power, and are any of them triggered here? And we were able to find none, and our opposition in their briefing also pointed out none. So
Well, but
I
think
understand.
The argument is, even in Plout, the Supreme Court of the United States said there is a separation of powers problem if we allow the legislative branch to overturn judgments of the judicial branch. And in the U.S. Constitution, there isn't even a separation of powers clause. And we have one express in our Constitution. So if anything, you would expect that the protection that we would have for that separation of powers is stronger. And we have the Gardner case. So doesn't that say we've got to be very cautious about allowing the legislature to meddle in our judgments?
I think that where I would assign a much different importance than your question implies to federal law on this issue. And I think that the difference between our constitutions is far more fundamental than whether there is a specific clause that mentions separation of powers. We have a separation of powers clause, but this court has pointed out previously it states the general principle, but it is the rest of the Constitution that puts the meat on the bone and says where are the specific restrictions on the legislature or on other branches. But because the federal government, because the legislature only has limited powers that were given to it by the people in the federal Constitution, that's completely turned on its head in the state Constitution. And here, the legislature has all those powers except for those that are expressly prohibited. So for that reason, I don't assert that we should assign any particular importance to federal law on separation of powers, because it is such a radical, fundamental difference in the starting point for those two constitutions.
So I'm wondering, even if we were to say that Section 4.2b is constitutional, if it really helps your clients, because as I look at the statutory language, what it says is during the revival period, the section revives any civil action for child abuse otherwise time barred as it existed immediately before the enactment of this act. Well, your client's claims immediately before the enactment of this act weren't barred really because they were time barred. They were barred because they had been dismissed with prejudice. So aren't you right back in the position you were originally? You've got in other words, do we even need to reach res judicata? Because your clients had final judgments against them, dismissing their claims with prejudice. And as I read this provision, all it does is take you back to that point.
Our claims were absolutely time barred by 152 as it previously existed, because courts told us that they were time barred as it previously existed. There's been no other change.
I understand that that was the reason that the court dismissed the claims with prejudice. But it seems to me you're in a materially different situation than a plaintiff who had never brought the claim. Because again, we're going right back to the moment just before this became law. I think that's what the statute says we do. And at that moment, your clients weren't in the position of someone who had had a claim, or who had a claim, except that it would be time barred. Your clients were in the position of someone who'd had their claim dismissed with prejudice.
I think that would be a meaningful distinction, and that's the distinction that the Court of Appeals drew fairly. But I think that would be a meaningful distinction if there had been some other basis.
I'm actually not saying it's res judicata. I'm just saying that your clients are barred. Yes, it's related to the statute of limitations. That was the underlying reason for the judgment. But your clients are barred because even if we apply the language of this statute, and you go back to the day before the statute was enacted, their claims are dismissed with prejudice.
Here's what I'll say about the language of the statute. Any civil action for child sex abuse otherwise time barred by 152 as it previously existed. These are definitely civil actions. As Justice Deed said this morning, there's nothing illegal about filing a case where the statute of limitations has lapsed. It's still a civil action. They're clearly for child sexual abuse, and I'll defer to Mr. Stradley's arguments that he's made this morning on that. They clearly were time barred by 1-52 because that's what a court told us. They were time barred. Our argument is that there is not a distinction between if you were time barred because a court said so or if you were time barred simply because you hadn't brought your case.
Well, I might agree with you if there were a period after GS 152, but there's not. There's that additional language that says if this applies, or if you're in this category, your claim is revived as it existed immediately prior to the statute, and your claim was dismissed with prejudice. And just to follow up, if we do think that to interpret this provision in the way you'd have us interpret it would create a separation of powers problem, shouldn't we interpret it to avoid that problem?
I understand the doctrine of constitutional avoidance, but I don't think that the doctrine of constitutional avoidance takes away what I believe to be the plain language of the statute. And I want to address more directly the portion of the statute that you're talking about. You're focusing on the last part of the revival provision, time barred under GS 1-52 as it existed immediately before the enactment of this act. What the legislature is saying is, were these claims barred by this statute before this change we are making to this statute? I don't believe that it's saying, what was your situation a day ago? It is saying, were your claims barred by this statute as it existed a day ago? And I think that those are materially different things. Our claims were time barred by that statute as it existed a day before the Safe Child Act was passed. I don't think that that language at the end, just based on the plain language itself, exists as a limiting clause. I think it exists to clarify not just time barred by this, that, or the other, but time barred by this specific statute as it existed before the change that the legislature was making right there in that provision. So based upon that, I understand. Yeah.
So you're just so I'm clear, you're saying the as it existed applies or modifies 1-52 and not any civil action.
I think that's right. And I think where it comes in the sentence clearly indicates that. It is saying, were you barred by this statute as it existed yesterday before this change we're making today? That would be my contention on that.
Well, not to beat a dead horse, but you've talked about Gardner, but we also have this language in Hogan, which does cite to a specific provision in the state constitution. The doctrine of separation of powers embodied in Article 4, Section 3 precludes the legislature from enacting a statute which alters a result obtained by final judicial decision before the date of the statute's enactment. I mean, if we take your position, aren't we slamming right into that interpretation of the state constitution?
I think that's already happened, Your Honor, because I do not think that Hogan, two things I'll say about Hogan. One is I don't think it meets the dictates of Harper versus Hall because I don't think it's saying here's a specific prohibition on legislative power, not a general statement about separation, but a specific statement of prohibition on legislative power that is violated beyond a reasonable doubt. And second of all, there is no question that the change that was made in Hogan was not procedural whatsoever. It actually was changing the definition of infectious disease in a workers' comp case for someone who had been unsuccessful because their infectious disease was not compensable under North Carolina law. So it was unquestionably not a change of procedure like a statute of limitations, but a change of substance.
So do you think in Harper that the intent of the court was to call into question all of our precedents interpreting the state constitution if they don't expressly apply the Harper methodology, that everything's sort of up for grabs?
I wouldn't say that, but I think that Harper provided very necessary clarification. If we look at the cases that both opposing counsel and I cited in the Court of Appeals, there are contradictions there. The Hogan case, I think, relies upon the fact that there was a substantive change, but in Wharton, where there was no separation of powers, there was a substantive change. You might argue that Wharton, you could only change the law because the case was still pending on remand, but in Gardner, you couldn't change it even though the case was still pending. I think that there was a lot of ambiguity and disagreement in these, frankly, very few separation of powers cases that we had. And I think what Harper does is provide a very clear framework for how we're going to decide that going forward. And as I have been
I guess
arguing.
my response to that would be, because I understand it's very in vogue right now to sort of hang Harper v. Hall on this court like some kind of albatross, but I view that precedent is completely consistent with what is happening here and with a case like Plout, because the argument would be, we've got to show it's unconstitutional beyond a reasonable doubt. Well, what the General Assembly is attempting to do, if your reading is correct, is that a court of competent jurisdiction entered a final judgment with prejudice on the merits in the case. That's how it works when you're dismissed, when you get a dismissal like this. And the General Assembly is now trying to say, well, we won't like it, so we're going to overturn that judgment ourselves. And the separation of powers clause just does not give the legislative branch that power over the judicial branch. And that to me, is beyond a reasonable doubt, that they don't have that power. So I don't see Harper v. Hall as having any real relevance here. The question is, for you, is there some reason that this principle in Gardner doesn't apply to you? And I just can't find one, especially when there are ways that you can set aside the judgment. Once the judgment is gone, you're like the plaintiffs in McKinney and every other case that we're discussing today.
I'm taking Harper at its face when it says we look to the text of the Constitution and we look for a specific prohibition. And we did that. We looked. And there are a lot of prohibitions on legislative power in our Constitution. In Article 1, there's the ex post facto law, which, as we know, applies only to criminal cases, not to civil cases. In Article 2, there are limitations on local laws and revenue laws. In Article 4, that sets forth the judicial power, there are restrictions on forming new courts, extra constitutional courts, or taking cases outside of the jurisdiction of the courts. There are specific limitations, and what I take Harper to require is that there has to be a specific limitation. And, folks' opinions about partisan gerrymandering, and forgive me for being a history nerd, but it was named after Elbert Gary, so I pronounce it that way. But people's opinions about that tend to change based on whether or not the party they like is in control. But there's a lot of folks that would say, oh my gosh, how can it possibly be okay that whatever party is in power at any given time can change all the maps so that they stay in power or that they multiply their power? How could that possibly be fair? And the response to that was, there is no specific prohibition on that
But
in our Constitution.
But Article 4 expressly invests the court with the judicial power. And what is the judicial power if it's not the power to decide cases?
I would say that it is the power to decide cases under the law that the legislature gives you. And at the end of the day, what the legislature did here.
But that's not what Article 4 says, is it?
Article 4 says the judicial power. There's not a res judicata clause.
We don't look to the legislature to ask them what is judicial power, correct?
No, I don't think you look to the legislature to determine what judicial power is, but I think the legislature passes the law and that this body and the other courts interpret the law. And there is definitely that I have seen anything specifically in our Constitution that says that there's a ban on retroactive civil legislation. And
Well, is there an express ban under Article 2 that legislature can't pass laws that impact the rules of appellate procedure?
There is in Article 4, and that was the Elam case that specifically gives, in the Constitution, gives this body the governing over the rules of appellate procedure, and when the legislature violated that, that was definitely a separation of powers violation, because that was very much an explicit constitutional power. And I also think there's a difference between a case like this where the legislature is saying, here's what, as a policy decision, we want the law to be to help a certain class of citizens, than there is in an example that Justice Dietz used earlier today. And that was in a case, I think it was Robinson from 1818, where the legislature said, you have to decide this pending case like this. You have to find these deeds to be valid. I think that was a violation of an explicit constitutional clause, because I think that's taking a case directly out of the jurisdiction of the courts and trying to decide a pending case.
But if the legislature can just come along and invalidate final judgments, then aren't you reducing the judicial power that the Constitution grants the courts to nothing more than legislative grace? We have whatever power the legislature decides we can have?
I believe that the legislature can pass a remedial statute to help a class of citizens that is limited and that would pass constitutional scrutiny under rational basis scrutiny. I believe that they can do that retroactively because there's not a specific prohibition on that.
So what's the limiting principle that keeps us from getting to the scenario I'm talking about, where the only authority this court has is whatever the legislature says it can have?
Because if it actually starts to create extra constitutional courts, it's going to violate an explicit prohibition of Article 4. If it actually starts to try to take cases out of the jurisdiction of the courts, it's going to also violate an explicit prohibition under Article 4. But I don't know of an explicit.
And let me just read what we're talking about, because sometimes that actually helps. The General Assembly shall have no power to deprive the judicial department of any power or jurisdiction that rightfully pertains to it as a coordinate department of the government. That sounds pretty express to me.
And once we determine what the power is that it has inherently as a coordinate branch of government, and as Your Honor has pointed out before, although the sands may have shifted from time to time as the powers of the branches, that there is not a constitutional requirement that these branches are co-equal, but they instead are coordinate. And the most serious of judicial considerations is the judiciary taking legislative power because it is a restriction directly on the people themselves. I agree that that is a statement. I think it's a broad statement. But I think that in order to apply this court's previous jurisprudence, it would have to be not only was there sort of a vague statement like separation of powers exist, or you can't take a power that another branch has, there has to be an explicit prohibition. I don't think we have that here. I would like to reserve my, I'll answer whatever questions anybody has.
I'm just wondering what you think the judicial power is then.
I think the judicial power is set forth in Article 4, and I don't think that there's any express prohibition on the legislature making any action that could potentially affect an open judgment in a limited circumstance. I don't think that there's an express prohibition here. I've got a little over 3 minutes. I'll reserve the remainder of my time.
Thank you, counsel. We'll hear from the appellee.
Thank you, Your Honor. May it please the court. Again, Joshua Davey of the Troutman Pepper Law Firm in Charlotte, here on behalf of the Roman Catholic Diocese of Charlotte, the appellee in this case. This court has time and again emphasized the importance of res judicata in our legal system. Almost 70 years ago, in 1958, in Poindexter versus First National Bank, the court called it a fundamental principle of jurisprudence. And more than 100 years before that, the court called it the foundation of all fair dealing between man and man in Armfield versus Moore in 1852. Res judicata has been a fundamental principle of Western jurisprudence before North Carolina was a state and even before North Carolina was a colony. And there's no dispute, and Mr. McGee acknowledged, that res judicata applies to the claims asserted in this case. All three elements are satisfied. There's an identity of the claims, there's an identity of the parties, and there was a final judgment on the merits almost 10 years ago in both of these cases. Because those claims involve the same causes of action, the same parties, and there was a final judgment, res judicata attaches as an independent bar to these claims, and they cannot be reasserted, the Safe Child Act notwithstanding. And we would submit that's really the end of the analysis that the court needs to undertake in this case. And what I'd like to do now is respond to the various arguments that have been made as to why the court, why the General Assembly could be empowered to set aside the preclusive effect of res judicata in the Safe Child Act. And that's multiple reasons why the General Assembly can't do that and shouldn't be understood to have attempted that here. First of all, as a matter of plain text, and Justice Allen was getting to this point in some of his questions earlier, Section 4.2b, that revival provision, allows a plaintiff to file a civil action for child sexual abuse, otherwise time barred under GS 152, as it existed immediately before the enactment of this act. In other words, the revival provision on its terms, by its own text, purports to revive only those claims barred by the Pre-Safe Child Act statute of limitations. Claims barred for other reasons, like res judicata, are not revived as a matter of the plain text of that provision. Now, Mr. McGee has argued that that doesn't matter because the reason that the prior claims at issue here were dismissed was because they were barred by the statute of limitations. But that argument fundamentally understands what res judicata is. Res judicata is an independent bar that arises when those three elements are satisfied: final judgment on the merits, identity of the parties, identity of the claims. None of those elements requires any court to examine the reasons underlying that initial judgment on the merits, other than to ensure that it was a judgment on the merits and not, for example, a voluntary dismissal without prejudice. Therefore, res judicata is an independently sufficient reason that the plaintiff's claims are barred here, just as a matter of the text of the statute, without even needing to get into any constitutional issues. And we would submit that as a matter of constitutional avoidance, if there was any doubt as to what the statute meant, that's the interpretation the court should go with under that principle. Now, if the plain text of the statute weren't enough, reading the provision as Mr. McGee advocates would violate two different provisions of the North Carolina Constitution. So first of all, as discussed when Mr. McGee was presenting his argument, this court has repeatedly held that enactments of the General Assembly that purport to undo final judgments of the judicial branch violate the separation of powers doctrine embedded in our state's constitution. And based on that constitutional provision that does not permit the General Assembly to deprive the judicial branch of the judicial power, which is quintessentially expressed in a final judgment.
But before you go on the separation of powers issue, do you think the General Assembly intended people in the position of the plaintiffs not to be able to pursue their claims simply because they did file them in a timely manner?
Your Honor, I think the intent of the General Assembly is known through the text that the General Assembly enacted. And that text, as I mentioned a moment ago, just on its terms, does not apply to claims or civil actions that are barred by res
And I'm
judicata.
sorry, they didn't file them in a timely manner, but they filed them prior to the enactment of the Safe Child Act. So.
Correct. And, Your Honor, I think the General Assembly's intention through the text was not to revive causes of action or civil lawsuits barred by res judicata. And the General Assembly, I think we presume they know the law. They know they can't do that.
What part of the text are you pointing to as support for your position?
Sure. So what I'm focused on, Your Honor, is in section 4.2b, and it says this section revives any civil action for child sexual abuse, otherwise time barred under GS 152 as it existed immediately before the enactment of this act. So what I'm focused on is the clause that begins with otherwise time barred. That's the reason if a civil action was barred by GS 152 as it existed prior to the enactment of the Safe Child Act, that's what the statute is intending to reach.
But they're saying that's precisely why their claims were dismissed, is because they were time barred.
But, Your Honor, the statute does not, on its terms, purport to void the res judicata effect of a final judgment, and I think that's the difference. Once a judgment becomes res judicata, the reasons for it don't matter. And the doctrine itself is intended to avoid a situation of a court looking behind it to sort of figure out what the reason was. And I think the text of the statute itself, because it doesn't even purport to go there, should not be understood to do something that the General Assembly lacks the constitutional power to do.
Okay, and so you don't buy either my proposed alternative interpretation that existed immediately before the as existed phrase, that applies to civil action and not 1-52. You think it applies to the statute as well?
Well, Your Honor, I think what that applies to is a civil action for child sexual abuse whatever that constitutes, and we argued about that earlier, but just whatever that is, right? If that civil action was otherwise time barred under the pre-Safe Act version of 152, that is the thing that is revived. I hope that answers Your Honor's question.
Thank you.
And getting back to the reason why this is the correct interpretation of the text, goes back to the principle I was getting at a moment ago. The General Assembly doesn't have the power to revive final judgments that are res judicata of the judicial branch under separation of powers principles that are very well settled. And we talked about the Hogan case, we talked about the Gardner case, we also cited Piedmont Memorial Hospital in our briefs. Each of these follow the same sort of pattern that's presented here. You have a final judgment on the merits, there's new legislation that has some impact on the issues that were in play there, and a losing party tries to take advantage of that new legislation to undo the effect of the prior final judgment. But in each of those cases, this court held that you can't do that because to do so would undermine the judicial power, would violate the separation of powers, which is embedded in our state's constitution. Now, Mr. McGee's argument is that the court can disregard those precedents because some, or at least two of them, dealt with substantive changes in the law as opposed to procedural changes in the law. And I think the reasoning there is that it's okay for the General Assembly to upend final judgments if they're based on procedural grounds, but not if they're based on substantive grounds. But that distinction, Your Honors, has nothing to do with the rationale behind the court's precedents in Gardner and Piedmont and the Plow case from the United States Supreme Court, which are rooted not in some substantive versus procedural distinction, but instead in the doctrine of the separation of powers embedded in both the North Carolina Constitution and, of course, in the United States Constitution as well. And I think we can see this by way of example. So let's say the General Assembly decided to pass a law that did away with Rule 12b-6 of the Rules of Civil Procedure. So no defendant can move to dismiss. They have to go to discovery. They have to file a motion for summary judgment, or they have to go to trial. But we're not doing dismissals on the pleadings. That would certainly be a change in the procedural rule. But I don't think anyone would believe that that would bring back all of the cases that had been dismissed under Rule 12b-6 that had gone to final judgment and were res judicata. Mr. McGee also made an argument that the court's precedents here aren't controlling because of the court's decision in Harper versus Hall. I'd like to make a few points about that. So one is, Justice Allen observed, nothing in Harper versus Hall comes close to overruling all of the court's prior constitutional precedents, whether they followed the specific procedure that Harper versus Hall laid out or not. Second, Harper versus Hall itself was a separation of powers decision. So it's a little ironic that it's being used as a sword, I guess, in the sense, when the court's fundamental concern there was observing the respect for the division of power between the General Assembly and the judicial branch. As Justice Newby noted, in our situation, there is an express constitutional provision that precludes the General Assembly from doing the kind of thing that Mr. McGee's advocating for here. So to the extent that Harper could be interpreted to require that, it's satisfied. But ultimately, I think Harper, if read properly, is really not a slavishly textual decision, but it's a decision about original meaning. Why do I say that? So the court there said that the task of the court is to determine the meaning of a constitutional provision by discerning the intent of its drafters when they adopted it. Courts first look to the plain language, keeping in mind the historical context of the text adoption. And the court went on to say that judicial interpretations of that text should consistently reflect what the people agreed the text meant when they adopted it. And then the court in Harper proceeded to analyze each of the arguments that were presented under the North Carolina Constitution as to why the General Assembly's redistricting plan was unconstitutional. And the questions the court asked were not merely, is there an express provision in the Constitution that says you can't have this law? The court looked at the original meaning of each of those provisions, traced it through history, went so far as to talk about writings of William of Orange in the 16th century. What does that tell us? That tells us that the court's focus there is on understanding the text as it was originally understood by those who adopted it. And why is that important? It's important because this court has already done that in the Gardner case and in the Hogan case and in the Piedmont case, where it has announced a rule, a long-standing rule, that the General Assembly cannot void final judgments of the judicial branch.
Can I ask you about the suggestion that was made, get your response to the suggestion that while the legislature can't undo a final judgment, a court could under Rule 60B. And I guess my ultimate question about that is that a sort of excessive formalism here? If it's correct that a court could, under Rule 60B-5, decide it's no longer equitable, that the judgment should have prospective application, or under B6, decide that there's some other reason justifying relief, and then the claim could be revived. It feels like, are we just putting a formalistic hurdle in front of this plaintiff?
Your Honor, I would disagree with that, Justice Earls, and the reason is that in the Rule 65 scenario, it's the judicial branch making that determination.
Right, but my point is, if the judicial branch can do that, should we remand for a decision about whether or not Rule 60B should revive the prior claims?
Well, Your Honor, I don't think so in this case because there's been no motion to set aside the judgments under Rule 60B. So if someone was going to try to do that, I think the appropriate thing to do would be to go to the trial court rather than, for this court to direct that that be done. But, and that would have to...
Isn't the answer because Rule 60B-6 vests a lot of discretion in trial courts. We as appellate courts don't have that discretion. For example, we can't find facts. There's various things that we can't do. Of course, we could review under a very strict standard of review a ruling on a Rule 60 motion, but those have to be filed in the trial court.
Your Honor, that's right. It's just not before this court right now, and, someone could try that, and that would have to be litigated on its merits, and that's just not, part of what this court needs to decide today. Finally, Your Honor, on the constitutional point, I do think the Plow versus Spendthrift Farm case from the United States Supreme Court in 1995, while not controlling, is highly persuasive. Because in that case, the Supreme Court confronted the same issue that's presented here, whether Congress could revive claims that were previously adjudicated as barred because of the statute of limitations. And the petitioners there made the same kinds of arguments that plaintiffs have made in this case, that statutes of limitation are different for different reasons. And what the Supreme Court had to say was no, that's wrong. And I'd like to just read for a moment, if the court will permit, briefly from the Supreme Court's decision, because I think it's persuasive here. What the court said was that the separation of powers violation consisted in depriving judicial judgments of the conclusive effect that they had when they were announced. And the court went on to say that it was irrelevant as well that the final judgment reopened by the statute rested on the bar of statute of limitations. The rules of finality, both statutory and judge-made, treat a dismissal on statute of limitations grounds the same way they treat a dismissal for failure to state a claim, for failure to prove substantive liability, or for failure to prosecute, as a judgment on the merits. Court went on to say that the petitioner's principle, this idea that the final judgments could be undone, would lead to the conclusion that final judgments rendered on the basis of a stringent or alternatively liberal rule of pleading or proof could be set aside for retrial under a new liberal or alternatively stringent rule of pleading or proof. That's my Rule 12b-6 hypothetical. And the court concluded by saying this alone provides massive scope for undoing final judgments and would substantially subvert the doctrine of separation of powers. And that's at 514 U.S. 228 and 229. Your Honors, very briefly, we also think there's a second constitutional problem with reviving judgments that are subject to res judicata, and that is under the law of the land clause. We've heard a lot about that today, but there's a separate line of cases going back to this court's decision in Dunham versus Anders in 1901 that we've cited that holds that a final judgment is a vested property right that cannot be deprived by the act of a General Assembly. And that's different from the rights that we were talking about in the earlier cases to rely on the statute of limitations as a defense. And I want that to be clear. But I think that is an independent constitutional problem that the court would run headlong into if it were to adopt a reading of the revival provision that would cover claims barred by res judicata. So in conclusion, Your Honors, we think the plain text controls, and we think the plain text doesn't encompass claims barred by res judicata. We know that interpretation is correct because going the other way would result in at least two very significant constitutional problems, and particularly with respect to the separation of powers doctrine, a long line of precedents from this court and the United States Supreme Court that make it clear that the General Assembly lacks that power. Your Honors, unless there's further questions, I'll stop there and we'll rest on our briefs for the remainder of the arguments.
Thank you, counsel. Rebuttal.
Your Honors, I'll speak briefly to a couple of points that were made and follow up on a couple of questions and then wrap up. I've only got 3 minutes. I will say, as to the first issue being whether or not this statute reaches my client's claims, I'll just urge the word any is a word that you don't have to add to. The word any is a word you would have to take away from. Counsel has essentially said they didn't explicitly say we're referring to cases that were dismissed before. And I would say when you say any civil action, you mean any civil action, and we fall under every portion of that statute. With regard to the conversation that we were having earlier about the text of the Constitution, Article 4, Section 1, General Assembly should have no power to deprive the Judicial Department of any power or jurisdiction that rightfully pertains to it as a coordinate Department of Government, nor shall it establish or authorize any courts other than permitted by this article. I think there's a specific prohibition there against restricting court jurisdiction. I think there's an explicit prohibition there against authorizing extra constitutional courts. One might think that it would perhaps be wise for it to be in our Constitution to say that the legislature could not use its power that we know it has to pass retroactive civil legislation. Perhaps one might say they shouldn't be able to use that power in a manner that would affect a prior judgment. But if the question is it expressly prohibited in our Constitution, it's not expressly prohibited in our Constitution. Your Honors, I'll just say I've been representing these two gentlemen for a long time. And I want to take my last minute or so to emphasize just how much they have in common with the other people that you've been hearing from here today. They are unquestionably victims of child sexual abuse. They unquestionably are subject to the damage that the General Assembly relied upon in passing the Safe Child Act and saying that the very damage that is done to you from this kind of horrible abuse is a major part of why people don't come forward earlier or even at all. And they are just like the other plaintiffs in that they have still never had their opportunity to go to court and prove what they know happened. They have only ever been able to talk about the statute of limitations. They have never been able to talk about what happened to them. What the diocese knows happened because they listed these allegations on their public list of credible allegations of sexual assault. What the police knew when they charged these guys, what one of them knew when he pled no contest to some of the charges, what the other one did when he said, no, I didn't molest these boys, but pled the fifth as to my client. What my guys are here asking for is the same thing they have always been asking for. They want their chance to go down to the courthouse, tee it up, put 12 in the box, and prove to 12 strangers what happened to them. And in that sense, they are in exactly the same shoes as every other plaintiff. And it doesn't change just because they tried earlier than some of these other folks did.
Thank you, counsel. Thank you both. Clerk.